Hi, I'm Chris Chimicles, president of Angeion Group, and welcome to our Leading Litigators series. Our series brings together some of the best and brightest class action practitioners from both the plaintiffs and defense bars, and most importantly, the attorneys that made case law. Enjoy our series.
Hello and welcome to a new episode of Angeion's Leading Litigator video series. Today it is our distinct pleasure to have one of the preeminent class action defense attorneys in the country, Mark Mester, the former global head of the consumer class action practice at Latham Watkins, join us. Mark, thank you so much for being here.
Thank you for inviting me.
So Mark, there are defense attorneys, there are class action attorneys, and then there are defense class action attorneys. And to say that you were a class action defense attorney is just putting it mildly. Can you give our audience the benefit of sort of your history, some of the major cases you've worked on, let them know who you are and what you're about?
Sure. I actually started doing this type of work as a summer associate at Mayor Brown a few years ago, 1982. I spent a summer at Kirkland and I did some more of this work. Got to Latham and have been doing a pretty steady diet of it since my second year at Latham. Took a brief detour and did some environmental work, but in the mid-90s started doing a very steady diet of class action work, and pretty much that's all I do and have done for the last 20 years. It's interesting what got me back into it. It was actually the 1991 amendments to Title VII. So I started doing employment work in the mid-90s when that was a sort of a growth industry, and then of course that got knocked out by Dukes in substantial part. So, but I've been doing consumer class action since essentially the mid-80s. So
tell us about some cases that you've worked on that our viewers might be familiar with.
I've got a current one, probably some have heard of, the NCAA class actions, both the medical monitoring, MDL, and now the bodily injury, MDL. I've done a fair amount of work for Honda. Sure. So there's the Civic Hybrid class action was one that got some notoriety. It's a long list. I sort of lose track.
Sure. So the NCAA one was one in particular that I was thinking of. That's obviously well known, and obviously it's a settlement that has implications for years and years and years to come. Right. How is it to counsel a client on settlement implications that go beyond probably even the current term of the person you're speaking to? Is that a real challenge?
Yeah, it is. I mean, you can only do your best. I mean, I think as Judge Lee has aptly said at some point, none of our crystal balls are perfect. Right. So we only can do what we can do, but we do our best. And I think in that instance, we felt all really quite comfortable on both sides of the case, and I believe the court, I mean, it's still subject to final approval, obviously, but I think we're all quite comfortable that we've amassed the necessary data and information to make projections, and we've done that.
So in the consumer realm, which is your bread and butter these days, we've seen a series of cases that have an impact on the practice. First, Carrera. Second, I would say probably the second largest or development has been Spokio. And I just want your opinion on sort of the current state of consumer law vis-a-vis these large Supreme Court decisions and any other changes that you think our viewers should know about.
Well, I think that the dust is yet to settle on all those. I don't think we know quite what's going to come of them. My sense is always that when those types of decisions get rendered by the Supreme Court, there are persons, I think, in the class action defense bar that maybe overplay their hand slightly. I remain of the view that we've yet to see the death knell of consumer class actions in spite of the persistent efforts by certain quarters of the defense groups to achieve that. But I really do think the dust is yet to settle on how that all gets parsed out. Far be it from me to try to predict that.
Right. So as we sit here today, we're in or around the comments period for the proposed amendments to Rule 23. And I've asked other guests recently about this, but I'm particularly interested in hearing your perspective on two of the proposed amendments. One will be the provision that deals with objectors, which I'm sure you deal with every day in your practice. And the second would be the provisions on notice. So if you could sort of walk us through your thoughts on those items.
Yeah, I do have views on both. I'm not sure how perfectly well formed they are. I think, you know, I find myself oftentimes in enough different situations that I feel like I can see both sides of a lot of these issues.
Right.
I can see benefits, for instance, to some of the proposals with regard to objectors. On the other hand, and you know, this may be blasphemy, but there have been certainly circumstances where I've seen the benefit of objectors.
Sure.
And they're not, if you try to paint with too broad a brush in this area of the law, you'll usually make an error. And so I try to avoid that. I think it's very difficult to craft rules to cover such a broad-based sort of cast of characters, cast of cases, et cetera, et cetera. It's difficult, and I don't envy the task of those that have to do it.
Sure. You said you've seen, and first of all, I don't think it's blasphemy. I don't think, you know, I speak to a lot of people in the class action bar on both sides of the V. I think that the majority consensus is that legitimate real objectors who are coming forward on a one-off basis to try to make a change in the settlement with the proper motivation are value in the system. I think that the overall distaste for objectors comes from, you know, a very small handful of the professionals who we see time and time again and use this device more or less as a shakedown.
Yeah.
So I don't think it's blasphemy.
I think a lot of my side of the V would say it is, but
Right.
I
Fair
agree.
enough.
I agree with you. Yeah.
Okay.
Yeah.
And as far as notice, I mean, obviously that's another situation where you have to be cautious about painting with too broad of a brush.
Right.
But what's your opinion on the current state of notice as it affects corporate clients?
Yeah, I think we are on notice. I think it's a little more clear-cut on notice than it is on objectors. I feel like a notice where it routinely feels to me like we're still in the dark ages. We find ourselves going back to look at a 1950 Supreme Court decision, namely Mullaney, and that becomes, which of course wasn't really even a class action,
Right.
and that becomes the sort of predicate for all that we do. And I don't know how much sense that makes in a perfectly rational world. Having said that, I also am mindful of how difficult it is to fix that. It's not easy.
No, I agree. So one other question I have, how much do you have a role in sort of counseling your clients how to avoid having you defending them in litigation as opposed to just coming in, you know, when they need the big guns?
Yeah. Well, it depends a lot on the client. We have a number of clients that we do exactly what you've described. We have other clients that, you know, call us after the fact when the case has already been filed. So
Right.
I enjoy the counseling. I like doing that, and I have a colleague who likes it very much as well, and she's very good at it. But it's not universally the case.
Sure.
To be fair, a lot of clients in a lot of industries don't ever see a class action for a number of years, and so they're not attuned to it, and suddenly one lands on their desk and it's a big shock.
Sure.
So to expect every potential client in America to see that far ahead would be asking a lot. But on the other hand, there are a number of clients who see them all the time, and those are typically the ones we do more of the counseling for.
Right. That makes sense.
Yeah.
Well, Mark, this has been fantastic. I really appreciate your time, and I think our viewers will really appreciate the insight.
Sure.